Hey, and welcome, and thanks for being here. Now, today, this webinar, this lecture is going to be on intellectual property law, and how things have migrated from tangible assets on the balance sheet and what companies are mostly made of. The income producing assets in companies used to be primarily tangible assets, things that you tangible mean things that you could kick and touch, machines, trucks, factories, those kind of things, computers. But now things have migrated to products of mind, right? And so those are called intangible assets, and that is basically IP, intellectual property. There's four different kinds of intellectual property. We're going to go through those, and just so glad you're here. So let's get started. So here's and put up the slide deck here. So yeah, intellectual property. It's your invisible balance sheet, and really, what you want to be able to do is really understand legally. Now, this is about business law and intellectual property, and to protect what you build or lose it. And that's really a terrible thing, a real challenge. And IP is your invisible balance sheet, right? It may not appear in your financial statements. It does as intangible assets if you decide to capitalize them, or else they'll just be expense. But they're the engines, the income producing assets, the engines of making money in most companies today, especially certainly digital first companies. It's often the most valuable thing your company owns. And so it's the things that help you make money, and it's also the things you sell when you make an exit. So interesting down here, 1975 tangible assets that we talk about, 83% of the S&P 500 companies, 83% of the value was tangible assets. 2020 intangible assets, IP, made up for 90 plus percent of the market value. Just an amazing transition. So, as we were saying, there are four different kinds of protection, IP protection, four different categories of intellectual property. And there's trademarks, right? And that's your branding, your identity, your logos. That's where you see the little R, the registered trademark sign. And it's names, logos, any mark that identifies you in the marketplace. And then there's copyright. That's your content, right? And your code, and it's software, writings, designs, photos, and that's automatic. As soon as you make something, you own the copyright. You don't have to go. You used to have to go through and file things to get the copyright. If you made a song, or if you wrote a book, but now it's automatic. But it's only enforceable if it's registered, right? So we'll talk about that. Patents. Now, patents are inventions, right? And you get a 20-year monopoly on that. No one else can do whatever that invention is for. It has to be there's four categories. That it has to be non-novel, non-obvious, and useful inventions. And then there's trade secrets, right? The most famous one is Coca-Cola. The formula for making Coca-Cola is a trade secret. It's not a patent. They keep the formula locked in a safe, and no one knows it but just a handful of people. And that's process and know-how, like the Coke formula. And it's unlimited protection so long as it's kept secret. So that's really the key there. So that's what we're going to be talking about here. And let's see, let's go to the next slide here. So why does IP, intellectual property, IP short for intellectual property, you know, matters for your company, to your company? Why does it matter? Well, it protects a competitive advantage, right? If you have intellectual property, if you have things that no one else has, you have a moat, you have a competitive advantage in your industry. And it enables monetization. You can license the IP to others, you can license it and generate royalty revenue that way. And you can use patents as leverage, in deals and negotiations. It's an increased valuation at exit. That's what your acquisition partners, your acquirers, are going to pay for it. Defensible IP, you know, clean, assigned, it increases value and eliminates, reduces deal risk. And it attracts investors, right? Patent filings signal novelty and credibility. If you have filed for, patent pending, and if you file for patents, you're in a great position. IP portfolios demonstrate that you're building a company that's going to last. So let's talk about each one of these in kind here. So trademarks. Let's start with trademarks. So, building a brand that you actually own. I mean, this is, branding is so critical, and that's what a trademark allows you to have is a brand that you protect and no one else has that, right? So when you're doing a trademark, there's different types of, the trademark strength. Getting a trademark, if you go and just, try to trademark you know, uh, so and so Federal Credit Union, it's too explanatory. You have to have a novel name, something that's a lot of times either random or a made up word, like Google, like Xerox, like Kodak. Those are words. If they're fanciful, those are the strongest words to brands to have trademarked. And then if it's arbitrary, it doesn't really relate to something like Twitter, or Apple, Amazon. Those are words, right? The Amazon River and Apple is an apple, but those are arbitrary as related to computers or whatever, online, shopping, stuff like that. So if it's arbitrary, that's relatively strong. If it's a suggestive word, that's less strong. And if it's descriptive, like cold and creamy ice cream, that's going to be weak. And if it's generic, like computer for computers, you can't trademark it. So it's tough to this is it's tougher to you can't trademark generic words. It's really difficult to get a descriptive word. You can get maybe a narrow definition for a narrow domain where you can use it. But then as you go up that ladder here, suggestive, arbitrary, fanciful. Really, what you want to do is have a fanciful word. Um, Now, I got trademarked for MBA ASAP for business, even though ASAP is a phrase like as soon as possible and MBA for Master of Business Administration. But I changed the S in ASAP to a dollar sign, and that allows me to make it unique and get a trademark around that. I also got a trademark for my publishing company for my books, Bisbee Press. And Bisbee, Bizb, is a made up word, so it's fanciful. So that was stronger, and it was relatively easier to go and get the trademark for it. But, so here's the process: clearance, registration, protection. You know, and I'd encourage you. You can do this yourself. And I even wrote a book on how to file your own patents, and I've done that many times. But um, I also encourage you to use lawyers. They're really, really helpful in really doing it right. Unless you really want to get into the weeds and do this yourself, you can. But it's good to have a lawyer. Um, so there's a basic search fee where you go to uspto.gov, and that's the U.S. Patent and Trademark Office, and that's where you look up your company name. Now this is U.S. centric type of IP protection, but these type of laws transfer to all countries where you have some sort of a legal framework around intellectual property protection in business. So this should transfer pretty well. And then so you do the basic search at see if there's anybody who already has that trademark. Um, and then you go for the search of the registered trademarks and look at all that. And that's an attorney conducted, search. And then intent to use file before launching to secure it, you file it. And then the registration process takes about a year, and that grants, your ability to use that trademark symbol. And then you can go and do international filings too. So now let's talk about patents. And patents, a $500 investment worth $1 million. It's an incredible way to create assets. Now, the $500 investment is if you file the patent yourself, it costs there's $500 in filing fees. But because of the U.gov, that site, you can do the patent searches yourself online. It's a searchable database of all the patents that have been issued and are pending. And that makes it actually doable, by yourself. In the past, that wasn't available. You had to have a lawyer, and then have another law firm that they farmed out to in Washington, D.C., that would go to the patent and trademark office and actually physically go through those files. So it is something that you can do now, we can do that, and we can actually make in a patent on average is worth about $1 million. And if you can file one for $500 and get it, think about, you do that 10 times, and you got a $10 million portfolio of patents. It's a nice way to make you know a, a company, or just a patent portfolio that's very valuable. So here's the patent requirements, right? There's four requirements for to be patentable. And it has to be patentable subject matter, like process patents are the most common. Machine, manufacturing, composition of matter, abstract ideas, and laws of nature. Laws of nature, obviously, you can't patent that because that's already been patented by, the deities that exist. So it has to be, a patentable subject matter. It has to be novel, meaning novel means new, right? Not previously disclosed anywhere in the world. Now, if you discovered or invented something that is novel, and you write a paper on it and publish that paper or something at a conference, if you're an academic or something, that's no longer patentable. You have to file for the patent before you disclose it. A public demonstration before filing, can destroy the novelty. And it has to be non-obvious. If it's something that's just obvious, and this is something that the patent examiners will look at, if it's obvious, an obvious variation of that someone skilled in the field would be able to figure out, then it's not patentable. And that's sort of a gray area. It's something that that's a call of the patent examiners. And sometimes you can, go back to them and go over those kind of things and see if they come back with a non-obvious, issue. And it is the most contested requirement in patent disputes. And useful. It has to have a practical application. And this is a pretty low bar, as I say there. Any real patent, clears it. And so there's three types of patents. Utility patent, those are the most common. Those are the workhorses. They protect how an invention works or how it's made. And you get 20 years protection from the filing date. You're basically granted a 20-year monopoly by the government. After that, though, the patent lapses, right, after 20 years, and then other people can make that thing. That's what happens, especially in the drug business. You see what they call generic drugs. Generic drugs come after a patent expires after 20 years, and then lots of people, come in and start making that drug. So and drugs get cheaper at that point and stuff too. And that's just one example of when a patent lapses, other people start using it. A design patent, that's ornamental appearance and things like that, how something looks. Design patents can be very valuable too. Think about like Apple, these design heavy companies that have a lot of design patents on their products. And a picket fence is an interesting type of strategy where you file multiple patents for different aspects of things and create a more defensible area around your invention. And they call it a picket fence, sort of like a fence, that you'd see in in somebody's backyard or front yard, a picket fence. So the next thing we're going to talk about here is trade secrets. And when to stay quiet. It gives you indefinite protection, but you have to keep it secret, which is pretty difficult to do. If you have people working for you and they learn the patent, well, maybe they'll disclose it, or somebody might, secret, industrial spies come and try to figure out what that process is, or whatever you're trying to keep secret. So you really have to be very vigilant with this. I mean, that's the risk with doing trade secrets. So here's, it's a strategic choice, because like I said, there's risks, there's pros and cons to patenting things and to keeping it as a trade secret. So a patent, you get the 20 years from filing. So one of the risks with patent is that you're doing full disclosure. Now, other countries where you maybe didn't get patent protection, or, other people, they look at the patent records and see that full disclosure of that patent, and then maybe they figure out a different way to reverse engineer and build something that's similar, that doesn't infringe on your patent, but does kind of the same thing. So you're actually really, exposing what your idea is, and you don't do that with a trade secret, right? The protection is strong, and but defending a patent is also the other thing. If somebody infringes on your patent, you have to tell them not to, and then you have to take them to court. And a lawsuit, a patent lawsuit, can cost you $1 million to $5 million. So just because you have a patent, people, unscrupulous people, can still infringe on it and then count on the fact that you may not have the resources to go and defend that. And that's sort of a problem with patents, and another reason to maybe keep things trade secret. And the risk of reverse engineering, you know, is irrelevant once the patent issues. Yeah. It's best for inventions embedded in products competitors can buy and reverse engineer. Because if that's the thing, if you have a product and somebody can buy it, take it apart, figure out how you're making it, and you don't have a patent on it, then you could be in trouble. But once you have the patent, they can take it apart and find out how you make it, and you've already disclosed that anyway. They can't make it because you have the monopoly on it. So let's talk about trade secrets. Well, the duration there, it's not 20 years. It's as long as it remains secret. It's indefinite, right? And there's no disclosure, no registration, no fees, which is nice too. Protection is fragile because of reverse engineering, right? Independent discovery could happen. That's legal. And one employee leak can destroy the protection. Yeah. For formulas that never leave your facility, and they're, the Coca-Cola formula is a strong example of that. So let's talk about ownership. And the rules, may be different than what you think. Payment for things does not equal ownership. There's assignments and works for hire, these kind of, employees, contract people and stuff. You could run into problems that you didn't really, weren't really anticipating. When you thought you paid for something, you own it. It may not be the case. So let's think about this. Here's who owns the IP. And these are kind of rules that can surprise founders. So this is something that you really need to pay attention to. So full-time employees, work created within the scope of employment is work for hire. The employer owns the work automatically. That happens a lot of times. I've talked to people who are scientists, they work or academics, they work for an organization, they make a invention and it's a legitimate invention, and they think, oh, now I can go and make a company around this and stuff. And then to their sadness, they find out that they don't really own it. Their company owns it. So really you have to make sure about that when you're employed by somebody, and rightfully so. If they're paying you to work and you, through your work, discover something, there's a fair argument that they should own it. So that's something. If you're on the employment side, you're an employee, make sure that your employment agreement and the rules around that. Independent contractors, you contract somebody and they own their work by default, even if you paid for it. Software, logos, marketing copy, all those kind of things. The contractor owns it unless you put that in the agreement. So co-founders, each co-founder, personally owns the IP that they create unless a proper assignment agreement. And that's all about assignment agreements that transfers ownership to the company. Very key if you're starting a new company. And vendors and agencies, the vendor owns it. They own the design, the code kind of thing, just like independent contractors, the creative parts of things they make, until a written IP assignment transfers it. So it's key to get those agreements in place. Can't say that enough. So here's a case study, how deals fall apart. An acquisition, here's the scenario, right? An acquisition conversation starts. The acquirer's team starts doing their due diligence, looking in the company, and they ask, who owns the code? Who owns the software? Is it properly assigned to the company? Where are the trademarks on file? What trade secrets are documented? You have to have all this stuff, documented. It's critical. And the founder discovers at the worst possible time, right? You're getting ready to sell your company with real money on the table. They haven't, they've been building on something that's not going to last. They didn't do the work. The developer never signed an IP assignment agreement. The brand name was never trademarked. A similar mark is found. Provisional patent lasts. Now, a provisional patent, you can create a provisional patent, and it's really a simple application. A lot of people are seduced into doing that. But within 1 year after you do the provisional, you have to file the utility patent. And So you might as well just file the utility patent right away. A provisional really doesn't give you anything. Yeah, provisional patent lapse and the utility was never filed. Great. The contractor code was never, software was never properly assigned, and years of building and the IP is not clearly owned. That is a terrible time to discover that happened, right? Don't want to be that person. That's why we're going through this stuff now. So the protection toolkit, IP assignment agreements, all creators have the IP assignment agreements in place. And this is where you want to get, you want to have a lawyer. You want to have somebody who's writing these, managing it for you. One of the first people you're going to get on your team is a good business lawyer. You want an accountant, and a good business lawyer, something along those lines are critical. Because even for filing your corporation papers and stuff, your LLC, you need lawyers. So every founder, employer, contractor who builds anything must sign a written IP agreement. It transfers the ownership to the company. It's foundational type of stuff. Non-disclosure agreements, NDAs, so that any external property. So if they see sensitive information, they can't share that with other people, and they can't share secrets. Work for hire clauses. Designate qualified contractor. Work is made for hire and a written agreement, and include the IP assignment clause. As a backstop for the work they do. And employment agreements. All your employees, a standard employment agreement must include confidentiality, like an NDA, IP assignment, and non-solicitation provisions. This really key stuff. These protect you. So this is getting kind of into like employment, getting into human resources and HR, but really critical from an IP standpoint. And that's what we're basically specifically talking about here, right? So let's talk now about some modern IP risks in the digital frontier. Everything's digital now, and with AI, artificial intelligence. Who owns the you know the intellectual property generated by your AI co-creator? So remote and global teams, if you have that, IP created, with international contractors can, trigger different default ownership rules. You really have to pay attention to that. AI generated content, the copyright office position is AI generated content without, meaningful human creative input may not be copyrightable. Open source license risk. If you're building software and you have open source parts in there, that could, infect your ability, excuse me, your ability to actually uh, create IP around that. So these things are really critical, and if you train AI models on third party, you may, third party content, and that's part of big issue with training AI models is you may have liabilities around copyright. You're using material that you don't own. So here are some expensive IP mistakes, right? No IP assignment agreements, assuming that payment equals ownership without having IP transfer agreements in place, ignoring trademark, until it's too late. If you're going to build a brand, get a trademark pretty quickly. Once you know what it's going to be, before you start investing a ton of money and time into building a brand, make sure that you have it trademarked and you don't have non-disclosure agreements in place before sensitive conversations. Well, then those people can go share that information and can breach things that you thought were sensitive. So you have to have non-disclosure agreements in place. And unprotected content, open source risk, right? We talked about that. Unregistered copyrights are difficult to enforce, and copy left, it's like copyright, copy left licenses can force open sourcing of your entire product. If you used some copy left, that's what they say open source things are instead of copyright, left and right, if you're using that type of software, that could infringe on your whole product, your whole code. So here, apply the rules. Here's who owns this in this case. Here's a couple of scenarios. A freelancer builds your product's core feature over 3 months. You pay him $15,000, and there's no written contract. So think, who owns that? The contractor default rule, right? They own it because you didn't have a written contract and you didn't have transfer that you own the IP for that they were developing because you're paying them. So what's the risk? You share your startup idea. Here's another one with a potential co-founder over coffee, right? Somebody, a potential co-founder. There's no non-disclosure agreement in place. They get excited and then go and build it themselves. Oops. You didn't have protection. They could go and use that. You didn't do an NDA. It's good. You have to have those signed up front. So here's an IP strategy by stage, right? We talked about these different stages, S1, S2, in that first video at the beginning of the course. But first, when you have the idea, the S1 is the idea stage of a company. Search and clear your brand name right away. If you're thinking of brand name, make sure that it's available. Make sure somebody else doesn't have that. I've seen that happen not many times, several times, where somebody built something, put it together, even a restaurant, and then they got tapped on the shoulder, say, "Hey, we own that restaurant name. You have to change your restaurant name, or change your company name after you've had the company for years." And it's just a terrible position to be in, right? So when and get IP assignment agreements in place, and identify some potential patentable innovations that you're doing. And then when you launch, file a trademark applications, get your utility patent filed, you know, establish trade secret protection protocols, and make sure that all the employees and contractors have agreements that include IP provisions. And then when you're scaling up your company, S3, continue to file patents, monitor for infringement in the marketplace, evaluate licensing opportunities. That could be a great revenue stream for you. And conduct an IP portfolio audit and make sure everything, all your documentation is clean and all that kind of good stuff. So we've gone through this, we've gone through it pretty fast, but it's also in my book, Business Law ASAP, and you can go back over this. But IP, intellectual property, products of mind, you're basically building things out of just your thoughts. It's an incredible way to create value and to create a valuable portfolio, for yourself. So protect what you build, right? Before the acquisition conversation starts. Structure the ownership early. Who owns, all the assignments, agreements, NDAs, and law plus strategy. It's not a legal intellectual property is not just a legal formality. It's a business asset. It's business strategy, and that's where you create value. So I really hope this was useful to you. It's been very useful to me. This is where I spend a lot of my time in my companies is working on intellectual property and creating assets and really getting all this stuff straight. So I hope you find out that you do the same kind of things, and all of a sudden you have a multi-patent portfolio that's worth tens of millions of dollars. I mean, that's just a great feeling, right? So go get them, and I'll talk to you soon. Bye.